5 minutes for your information.
Can you put my slide on? Not yet.
A very good afternoon. Sorry, a very good morning, actually. And I hope that all of our attendees are doing well. Welcome on behalf of the JGU family. Today's webinar is titled Contemporary Challenges in Space Law. And today with us, we have Professor Dr. G.S. Sachdeva, the adjunct professor at Nalsar University of Law, Hyderabad. Professor Sachdeva has been one of the pioneer scholars in India in the field of air and space law for almost 4 decades. He is currently an adjunct professor at Nalsar. He was formerly an adjunct professor at the Center of International Legal Studies, School of International Studies, Jawaharlal Nehru University, New Delhi. He is a guest visiting faculty at National Law School of India University, Bengaluru, and several other law schools and universities in India. He is also a teaching resource for Indian Academy of Diplomacy and International Law, New Delhi, National Institute of Advanced Studies, Bengaluru, and several other institutions. He obtained his master's degree in economics from the Delhi School of Economics, the University of Delhi, and LLB, in which Sir was a gold medalist from Nagpur University, Nagpur. He pursued his research studies in international law and was conferred the degrees of Master of Philosophy and Doctor of Philosophy by Jawaharlal Nehru University, New Delhi. He pursued his postdoctoral studies in air and space law at the Indian Society of International Law, New Delhi. He has published over 60 articles in professional law journals in India and abroad, and has also contributed chapters in edited books. He has authored 7 books, 4 books on space law, 2 books on air law, and 1 general interest book on sociology. He is national panelist for drafting of space legislation for India. He is a peer reviewer for and holds an advisory position on the editorial boards of several reputed law journals in India and abroad. He has been selected as a member of the International Academy of Astronautics, Paris, for study group 3.26 on commercial exploitation of celestial and natural resources. He has also been recognized as an honorary Rosalind member of London Journal Press. I'm sure all of you are very excited to hear from Dr. Sachdeva today. Our commentators and discussants for today are Professor Dr. Biswanath Gupta, my dear colleague, who's an assistant professor at Jindal Global Law School, as well as Professor Alexander Milano, another colleague of ours, assistant professor, Jindal Global Law School. Professor Sachdeva, the floor is now all yours.
Thank you very much, Ankita. Thanks a lot. My slide. Professor Shrijit, faculty, and students. I'll be talking to you today on contemporary challenges in space law. And in that particular subject, I'll cover next. And in this, I'll cover challenges to space law, but I'll divide that in 3 parts. I'll discuss past challenges also, the present or contemporary challenges, and what are the future challenges. And I'll sum up my talk with a couple of suggestions. Before I start on challenges, I briefly recapitulate on the corpus of space law. First, when we talk of the lex specialis for space domain, I primarily talk about the UN resolutions. And the main point in that is it also absorbs in space law what we have as international law, but mutatis mutandis. Whatever changes have been made, they are to be accepted as specialist changes, and the rest of the international law becomes part and regulatory for all space activities. This lex specialist can be treated as a voluntarily accepted principles because these were part of resolutions of the United Nations. This was followed by 5 treaties, which we normally put it under Pacta Sunt Servanda. This is obligatory law, and these cover different aspects of space activities. And the basic among them is the Outer Space Treaty, which is the Grundnorm. The next we have principles, declarations, and guidelines. These relate to principles with regard to remote sensing. There are guidelines for space debris, and there is a main declaration on international cooperation, among other principles and guidelines. This becomes the normative law. Next comes, as part of the overall corpus of space law, are the national space acts, which more in the sense of regulatory laws of different states to regulate their own space activities, and also to discharge certain duties put upon the states by the Outer Space Treaty in trying to have continued supervision over space activities. And the last of all, which I also consider as part of space law, are the codes of conduct. These are the suggested best practices, like you have the European Code of Conduct or the Artemis Accords of the United States, just to mention a few. Now I come to challenges in space law, and I first talk of some past challenges which have been handled already. The first one was the Outer Space Treaty treated astronauts as envoys of mankind under Article 5. This was a very prestigious sort of a provision and gave envoys a status much beyond the normal envoys or diplomats. But what happened was this clause was not found to be adequate enough to cater to the problems of accidents and rescue from places which are normally not within the plan of the space activity. And hence, immediately after the 1967 Outer Space Treaty was an agreement on rescue and return of astronauts and space objects in 1968. So the challenge which came up was that envoys of mankind was enough to save and protect the astronauts, and we had to have an agreement on rescue and return of astronauts and space objects. The next problem came up on liability of launching states. And this particular liability of launching states was later, it grew into Convention on Liability for Damages. The next problem came up, or perhaps the challenge that came up was on the definition of launching state. The Outer Space Treaty, according to the Outer Space Treaty, launching state was the one which launches or procures launches, or whose territory or facility is used for the launch. But this was not found to be adequate because registration of the space object could be in a different name of a state, and the control and jurisdiction over the space object could be with yet another state. This complication created need for another particular convention, and that became the Convention on Registration of Objects, launched 1975. These were just some of the examples which I gave, where in the past there have been challenges to the space law or the outer space treaty, and these were rectified. Now I come to what exactly is our present state or contemporary challenges, which we are yet to face very directly and find solutions for that. The first challenge, according to me, is the privatization of space activities. So far as we know, the states were doing almost the state agencies were undertaking all types of space activities, and there was no problem, and they were governed by the treaties. Now a situation is coming where states are withdrawing and concentrating on exploratory and strategic space activities, and commercial space activities are being taken over by private sector. Now, the point why we are concerned about this is because business motivations are different. Business motivations of private sector are different from public policy, which is the guiding force for state agencies. Now, what solution can we have for this? There could be, we can say, a need for an ethical code for space commerce and industry. It's just a suggestion, because an ethical code would only be a normative law. But all the same, it has been our experience in space activities that normative law, by and large, is adhered to. The next problem, which is again a contemporary challenge, is space travel. Very soon we are going to have space travel. In fact, we can say that space travel started from Dynasty 2. Space travel started from Dynasty 2, who was the first private and paying passenger to travel into outer space. He traveled with Russian arrangements. Now, what happens is that when you have a contract of travel, the contract can be made in a way, the way the carrier wants it to happen. In fact, Dynasty 2 had a battery of lawyers who could work for him and work on a contract for his travel to the International Space Station. But this would not be so when it comes to a normal class family or a person traveling to the outer space. So what we need are that the carriers should not be able to contract out their liability for accidents. This is what had happened during when the air travel had started and come on that horizon. Next is that no person individually can give you enough evidence of what accident or what problem is. So the evidentiary burden of should be according to res ipsa loquitur, which means the facts speak for itself. So once the facts of the contract are provided, thereafter the burden should be on the defendant and not on the complainant. And then again, when the passengers travel in a capsule of 6 or 8 or 10, there are going to be some behavior problems or delinquencies. because the place where they travel will be very claustrophobic. And with the G effect, sometimes people may have problems. So the solution for this could be that we could have a treaty on the lines of air law, which could be the Warsaw Convention 1929, or it could be the Montreal Convention 1999. When we have these, a treaty on space travel, it should have also a procedure for dispute redressal, or it may have a separate forum. Next, please. Once we have space travel working fine, there is great possibility that we'll venture into what we call space tourism on the lines of what we have air tourism or civil tourism. Now, what happens is that when it's a touristic experience, there is a promise that you'll be able to see this, you'll enjoy this, you'll experience this. But at times it so happens that there are deficiencies in the service of the tourist promiser. And these deficiencies, as in the service, from what is promised as a tourist experience, becomes a point of dispute. So disputes would arise, and the problem would be where would be the jurisdiction. And similarly, there could be offenses by the tourist also, which can be called as crimes. And there is need to decide the jurisdiction on disputes which are civil and disputes which are criminal. So perhaps we need to have a dispute settlement forum for space tourism as well as for space travel. The next challenge which is coming up before the space law is commercial appropriation of celestial natural resources. What happens is that the surveys and remote sensing has proved that many celestial bodies have a lot of natural resources which are useful for us on the earth. And this becomes important because we have depleted most of our earthly resources. So our dependence on natural resources from the outer space and planetary bodies becomes important. And these resources, to give you one example, that there is an asteroid of the size of a football ground, which is believed to be pure diamond of that particular size, pure diamond of that particular size. So you can imagine how expensive and useful. I'll give an example of a useful material also. It is said that the dust on the moon and its crust are very rich in helium. And helium is one product which can be used for generation of electricity. It is generally believed that a quintal of this helium brought from the moon can serve a country for its power generation for 1 month, for just 1 month, and that too of a big country. So that means natural resources of planetary bodies are very useful, not only with regard to helium or the diamond which I've talked, it's also good for various other like iron and platinum and various other precious metals also. Now, at present, under the Article 2 of OST, where appropriation, we can excavate, we can bring that, but appropriation and commercial use or sale of such material is not permitted. So that means OST under Article 2 is a bar to appropriation of that for commercial purposes. But there is Moon Agreement, and which also has a common heritage of mankind clause. But Moon Agreement is little more permissive on this. Why on this aspect Moon Agreement? Because Moon Agreement firstly says that whatever material is useful on the planetary body can be used in any process whatsoever right on the planetary body. But to bring it down to the earth would mean a lot and would not be permitted because it's a common heritage of mankind. But at the same time, while the permit this exploration and appropriation and its utilization by human beings, there are certain contrary initiatives which have been coming up. The first is the US Space Act 2015. It authorizes its own nationals to compete for and exploit and appropriate that for their own commercial purposes. This law goes against the Outer Space Treaty and the common heritage of mankind. Another state with a similar law and similar intentions is the Luxembourg state, which offers that, okay, go ahead and do that. And any corporation which is registered in the Luxembourg state or the Duchy of Luxembourg shall be helped under the law. Here, of course, we must accept that humanity cannot wait for long for the law to amend itself. So I'll discuss this point later when I talk of the commercial appropriation as to how we can get over this problem. But that is not the judicious or the righteous solution. Nevertheless, that is one solution that is under the circumstances. Right, once we have commercial appropriation of celestial natural resources, there are going to be a lot of economic disputes, interference, or the other party has used my product or has encroached on my area. So this sort of economic disputes are bound to arise and would come up. There would also be need for a settlement forum. And for that, the solution could be taking the whole problem together of commercial appropriation. The solution could be one, amendment of the OST or negotiation of a protocol which permits. And the other point which I make here is, since the law is very slow and laggard, and humanity for its own needs of natural resources cannot wait indefinitely, the initiatives taken by the United States or even by Luxembourg, they can have an intermediate solution like, after all, the purpose is the benefits must flow to all states. So what they can do is deposit a certain portion of their profits for common benefit of states in an escrow account with International Monetary Fund or any other place. The next challenge which is coming up now and we are facing it right now is the security of space assets. As we know that we have a large number of satellites in outer space, and the major and the most useful satellites are in geosynchronous Earth orbit for communications, for broadcasting, and for other purposes. Another aspect comes up that these satellites are very expensive and they are very vital for our daily utility. They are extremely vital for aviation, sea navigation, or our daily communication like mobiles and things like that. Without these satellites, we'll find ourselves completely cut off. So these are expensive and very vital daily utility services. We also find that it's not question of satellites only. The trend which is coming up is constellations. And today you have constellations of 100 plus small satellites, or perhaps I could call that GPS of United States has a constellation of 64 satellites. And all these satellites are very vulnerable. Sorry, are very vulnerable. And the vulnerability to debris, which is a space debris existing already in the outer space, or through attacks. We'll discuss more about the attacks later, but suffice it to say now that all these space assets which we have in outer space, there is a lot of vulnerability from debris or from external attacks. So what is the solution for this? One solution could be individual security of each satellite. Here perhaps one of the idea which was mooted, shall I say, mooted by me in an article in 2009 and has been appreciated by NASA, and they have adopted this. The concept offered was space mines. That means a particular satellite could have 4 guards on the 4 corners or on the sides of that particular satellite. And should there be any threat or should there be any debris attack or a debris vulnerability, these space mines or guards will go and attack that so that the basic satellite is not harmed. And these small space mines go and either destroy that or eliminate them so that there is no risk and there is no damage to the satellites. Another important aspect which comes up is there is need for supported space surveillance, which we normally has as SSA, space awareness. It's a space situational awareness, which presently is provided and perhaps to put it, not provided also by the United States, because United States reserves the right to cut off this particular facility or awareness should there be an emergency on the United States itself. The next challenge which comes up is the protection of intellectual property rights. Since there is going to be industry and commerce both in outer space, there are going to be a lot of innovations. In fact, innovations have already taken place with regard to crystals, with regard to certain vaccines which need sterile atmosphere and crystals which need gravity-free environment. Similarly, with innovations, there could be new processes also which may have to be patented, and product specifications which will also have to be. So there is intellectual property rights which will come up or which will grow in outer space and would have to be done. Our present law does not consider this as an important issue, and we need to think how we can have a protocol to cover all intellectual property rights and allied issues. The next which comes up is crimes in space. We haven't talked much about it, and perhaps the first reported crime in space is Alan McLean. Alan McLean was a US astronaut at the ISS, and she unauthorizedly used the computer systems of the ISS to gain illegal access to the private financial data of her spouse, with whom she had estranged relations. The matter was reported to NASA for investigation and has also been reported to the federal agency as to where the privacy invasion has been done. This becomes the first reported crime. Actually, this is not the only crime. Crimes have occurred earlier also, but no action has been taken, or action has been taken in a different manner. Let me explain one or two past crimes to you. Take, for example, the United States entered into an experiment with copper needles. They spread millions of needles in the outer space to create a belt for a dipole communication. And these needles, when spread into the outer space, did not spread the manner in which they wanted it. They became plump and bundled into 7 bundles. And those 7 bundles of needles, very small, fine needle, copper needles, and they are circulating in that orbit. This was a bad experiment, and they did not consult any other scientists or any other country. Another state misdeed can be Bereshit. The Bereshit experiment was undertaken by Israel. What they did was they wanted to take a particular virus, the Bereshit virus, to the moon and carry out experiments. This particular Bereshit virus which was taken is a very sturdy virus, and this virus can live for 500 years, and it can dry up on the dry surface, and whenever it comes in contact with the host, it takes moisture from there and can become once again live and active. But what happened was that the Israel lunar module, which was supposed to land on the moon, crashed. And as a result, these Bereshit virus would have spread somewhere, wherever that be, on the moon. So what they have created is contamination, either on a planetary body, which is against the cost for planetary protection, or by the needles, which again has been a debris created in the outer space. These are not only the state crimes, there are individual problems also. For example, on one of the Apollo space ships, which went to ISS, which went to ISS, the astronauts were so worked out and cheesed off with instructions and orders from the NASA controller that they created a near mutiny. For 24 hours, almost one day, they remained incommunicado with the control center. This was a near mutiny, and in military parlance, it could have been treated as a very serious offense. But NASA didn't take it too seriously. Of course, they punished the astronauts in a different manner that they never came back to outer space again. Another aspect where astronauts have done not too great is when the US astronauts threw garbage in the outer space. And when this garbage was thrown, what exactly they had done was they had collected all their dirty clothing and threw it in the outer space instead of depositing it in a small bag where it could have been thrown and burnt or incinerated in the atmosphere. These are some of the past crimes. And if I were to talk about future crimes could be physical. We have talked of tourism and where people get together in cramped and ergonomically difficult situations. There can be a lot of outburst, emotional, psychical, or otherwise, which could express itself into physical crimes. Then we have talked of the commercialization of planetary bodies. And if that happens, there are going to be a lot of economic crimes in the future. The third category can be cyber crimes. These have started occurring. Perhaps if you are willing to believe, for 1 minute, it is believed that the Chinese had made American communications completely unapproachable. And that was the beginning. What will come in future through cyber, artificial intelligence, and various other applications of technology cannot be imagined so easily. But nevertheless, cyber is one which can attack even from the ground and need not necessarily be an attack of space from space. And the last of all, I call humanitarian. Humanitarian crimes will come out because in case of emergencies, in case of distress, in case of accident, all those who are on a planetary body should be helped by any other organization, any other country, any other institution, any other corporate who is working there. And if at all, for any reason of discrimination or any reason otherwise, they refuse to give them shelter, they can be punished under the humanitarian or called the international humanitarian law. Another problem which comes up more as a future is how exactly are you going to punish people who commit crimes in outer space? The case of Ellen McLean, which I've discussed already, was very simple. She was an American citizen, astronaut. She committed the crime while in the American quarters of the ISS. She committed the crime against an American national, and it has been reported, sorry. It was reported to the American authorities for solution. So that means the jurisdiction was American. But the jurisdiction can be different. Say hypothetically, in a tourist place, a crime takes place between people from different nationalities. And then there could be incongruent national laws. One country can talk of, say, for example, in India, we talk of contributory negligence, but Germany has got no concept of contributory negligence. We talk of a breadwinner in India. Russia has no concept of breadwinner because everybody gets according to his need. The next problem will come up will be juridical procedures. How exactly under what procedures are we going to tackle these particular things? Which country will take over the trial? So it's going to be difficult. And particularly the victims who are going to be individuals. The victims who are going to be individuals, how are they going to get their relief or get their justice? Because the treaties recognize only states, and the states only know of what we call is a diplomatic channel. And hence the problem would be how the individual complaints would be taken up on the diplomatic channel, which are very slow, legendarily slow. And hence there is need for a treaty to resolve incumbent issues which may arise with regard to crimes in outer space. The next problem which we have is space debris management. For space debris mitigation, United Nations has issued certain guidelines in 2007. But that is action for the future. What about our past sins? We have been, since 1957, sending out rockets and satellites. And today in outer space exist non-functional, rogue, or zombie satellites. Also, there is increase of density at the low Earth orbit, with the result you literally have to seek a window through this density, and it's not so easy to straight get into the outer space. And then we also have to retain a sustainable environment in outer space for our future generations. So what exactly are the solutions? First solution is, for whatever we have done already, we have to do space scavenging, and that is a technological issue. The other could be where we have non-functional rogue satellites, they could be serviced in orbit. These technologies have developed, but in order to be practical and useful, there are certain legal issues. The first legal issue comes up is the permanent sovereignty over space objects, which I talked of as the rescue and return of space objects and astronauts. There is permanent sovereignty, and no other country can touch a space object without the authorization from the country which controls that. Again, when this sort of activity takes place, like space scavenging or in-orbit servicing, particularly in congested areas, there is likely to be a damage to adjacent satellite or an object. And that sort of a damage can create liability, and what we need is immunity against that liability. And third would be, we need better space situational awareness so that we can maneuver. In fact, you'll be surprised to know that over the last year, there were about 3 emergency calls where the astronauts had to hide themselves into a module at the ISS in cases of emergencies. The next challenge comes up is planetary habitations. Moon Village is very well talked and people know about it, and so is the Mars colony. Even today, people from the Earth are willing to go to the Moon and the Mars on a one-way ticket to become the permanent settlers in space. They don't want to come back. Now, how exactly are we to reconcile this particular problem? And when we are thinking of creating habitations for human beings from the Earth, there are ownership claims from others, like the Church of Scientology. It maintains that we had our king Zeno, who was on the Mars, and we had a confederacy of outer space. And they believe, or at least that's how they believe, that whosoever was to be punished on the Mars, he was expelled and sent to the earth. So that means people who were punished on the Mars by King Zenu at that time were expelled from Mars, and they were sent out to the earth. So today the earth, we can call the population on the earth is from Zenu's, and they claim that Mars is ours. We'll get back. And even today, the Church of Scientology exists even in India and worldwide, and where they purify the souls and then say, yes, we'll transport you to the Mars again. There's another Thomas Mangan in 1948. He established, call it an outer space country, or what you call it, Celestia. And he even went to the extent of applying to the United Nations to say Celestia needs membership of the United Nations as a separate country, so that wherever men come in conflict with Celestia, we should be able to fight it out. Then there is Asgardia. They call themselves as a space nation, and they are the people who are the high intellectuals from the world, different nations. Now, that being the situation, in fact, Asgardia, to just give you one name is Professor Jaku, Professor Ram Jaku of McDonald is also a member of this, and we have a couple of members from India also. They believe, and they have sent a satellite into outer space, which is called Asgardia 1, and they want to consider themselves as a separate state from the Earth. There is another organization which is called All for Moonkind. One lady, Hanlon, she heads this organization. And surprisingly, this organization has got the observer status at the Corpus. Apart from these, there are a lot of frivolous claims on outer space and planetary bodies. I mentioned one of Dennis Hope. This gentleman registered moon in his own name in California, because California laws are very different. And whatever is treated as res nullius, they register. So he sold lunar realty to some people in 181 nations. And when United States landed on the moon, he billed NASA for landing charges. This case went to the court. Unfortunately, to Dennis, this was dismissed for various reasons. And one of the points raised by the court was that you do not exercise effective control over your property. There's another gentleman, Virgilio Pop. He's a Romanian, from the Romanian Space Agency. He filed his claim that he owns the sun, and he billed Hope for use of sunlight on the moon. Now, whatever be, these may be very frivolous sort of claims, but in any case, these claims have been made, and we need to clear it out and assert that non-appropriation is one which remains as the major clause, and celestial bodies or planetary bodies remain as our common heritage of mankind, which cannot be appropriated. The other point which comes up is how exactly, when the moon village or the Mars colony come up, how are you going to govern this? What will be the law? In fact, they are already, as guardians are saying, we'll make our own laws and we don't want to depend on the human laws of this earth. Since we are also talking of commercial angle of Moon Village and Mars, there is need for some sort of a long-term leases to be granted to those entrepreneurs who want to construct and create an infrastructure. This perhaps could be handled by UN, and we'll discuss it a little later again. The next is weaponization of outer space. Article 4 of OST is not enough. I hope I'm not exceeding my time.
Should be closing.
Okay. No, I hope I'll take 10 minutes. Article 4 of the OST is not enough. It bans only nuclear weapons and weapons of mass destruction. And it also bans only orbits around the Earth. But it can be circumvented, and it was circumvented by the Russians through a system called FOBS. FOBS is Fractional Orbital Bombing System. Under this system, it was, but on persuasion, they withdrew this system and no further development has taken place. There is also a nuclear test ban treaty which prohibits nuclear tests in outer space. This is okay, but what about the other challenges like kinetic weapons? It is said that if a kinetic weapon is fired in the outer space, the bullet will keep traveling as long as it has that particular orbit and the speed. Then we have directed energy weapons, something like lasers. In fact, lasers have been used and can be used to reduce the speed of space objects so that they come down into the closer to the Earth atmosphere and later enter the Earth atmosphere and incinerate and burn themselves up. The next is cyber and artificial intelligence attacks from anywhere. I just mentioned how China could silence the entire communication from the ISS for 1 minute for the United States. And the latest which we have is what we call as the ASAT, or the anti-satellite tests. China did first, America did later, and India has followed. If this race continues, the results can be right. Now we come to the last portion of my talk, that is suggestions. Now, what can be done? We have these problems, we have these challenges, and we have sorted out these challenges in the past. And in the past, we have sorted out, or we have tackled these challenges through agreements, conventions, and treaties. What we need today, again, is a comprehensive, holistic, and a futuristic revision of outer space treaty, but that could only be possible with simplified procedures and political will of major powers. We find that political will is lacking today. The will which existed in the 70s is not there today. and simplified procedures, because Corpus, which has been created by the United Nations, has got a system of approving any clause or treaty through consensus, and consensus is difficult to achieve. And that's one reason the negotiations within Corpus have taken extremely long time, and many have not been successful. The next, perhaps slightly easier way is an enlarged adherence to the Moon Agreement and its revision. Moon Agreement has not been patronized and acceded to by many countries. Even today, the number of countries who have accepted this, just about 17 or so. But Moon Agreement is a more flexible treaty with regard to, first is excavation and utilization. Number two, using and appropriating planetary material, and as such, we can use Moon Agreement for better and easier results. It can be revised. It need not have consensus. It can have majority voting, and the Moon Agreement can be changed, modified. While we talk of a new treaty, there would be need for a specialized, a professional regulatory and management authority to look into all the affairs of outer space and celestial bodies. We have today United Nations Office of Space Affairs. This is a very small office with very limited charter. What we need to create today is something like a World Space Authority as a professional body, which can give out leases, which can charge a cess on commercial activities, which can do a lot of things which at present we do not have a competent body to do. And that is where a World Space Authority would be required to replace OSA. And the last which I have to do is the need for a separate, independent, competent dispute redressal mechanism. And when we have a mechanism, we have to have an institution also which can handle these matters. And this can be specific purely for space matters for states. Why it's more important to have one is because the disputes are going to happen between the corporates and private spacefaring entities, and at times between individuals also. So we need a mechanism, we need a competent authority or a redressal system which can handle all this, because treaties do not recognize, accept states. And International Court of Justice only recognizes states. For any other individual cases, you have to have a tribunal, and that becomes a very long drawn procedure and a specialized sort of a thing. So we can have a permanent dispute redressal mechanism or institution which can handle not only states disputes, which can handle disputes between private spacefaring entities and crimes against individuals. Thank you very much. I must apologize. I've taken a little longer, but you'll bear with me. Thank you.
Thank you so much, Dr. Sachdeva, for this absolutely informative and insightful talk. And we're more than happy to have heard from you for so long, even if you think you exceeded the time, because this is an area which is going to become far more important for all of us in the coming future. And now I'd like to call upon Dr. Milano, Professor Milano, to take this discussion forward with all of us. Thank you.
Thank you, Ankita. Also, thank you very much to Professor Sachdeva for this illuminating presentation. It was a delight to hear all of these aspects that you have covered in your presentation. Also, I would like to welcome here my colleague, Professor Biswanath Gupta. I'm sure that all of us, we do have some questions. So I'm really interested. I'm really interested in your opinion on many questions, but I have narrowed it down, and I will start with the first one, which is in relation to the principle of common heritage of mankind that you have mentioned is covered in the Moon Agreement, and as you have very well clarified, it has not been even states have not exceeded beside France, I think, and it has not been ratified by any of the spacefaring nations. So in April this year, we have seen an act by the US President Trump, which was in the form of executive order, and just read it down, on encouraging international support for the recovery and use of space resources. So this became a very disturbing news for us, the academia in the field of international space law, as for many reasons, but one particular reason was that in this executive order, the United States president basically said that outer space is a legally and physically unique domain of human activity, and the United States does not view it as a global commons. So I'm very interested to hear your thoughts on this. And do you find it as some sort of a claim of national sovereignty, which, as we know, is forbidden in the Outer Space Treaty and the other agreements as well, the other 3 agreements? So what can you comment this particular claim in the executive order, please? Thank you.
Thank you, Professor Milanov. I very much agree with you. What United States, and particularly their Space Act 2015, is contrary to the Outer Space Treaty. In fact, what Outer Space Treaty gives to the states, no state can give more than that to its own nationals. The Space Treaty only gives you the right of exploration and gives you a right of bringing certain samples for scientific investigation. I know of cases and instances where part samples have been sold out in the black market. That apart, it's a very minor part of it. But excavating and exploiting and appropriating as private commercial property from the planetary bodies, which cannot be appropriated, it is incorrect for the United States to do that. What we need is either to have an amendment to the treaty if they really want it, or we should wait where all nations get together and decide what to do on that. But independently declaring, okay, my nations can go ahead, my corporates can go ahead and do that, it is incorrect. I've already written on this in the same lines that United States as a leader should not be behaving in that particular manner. It shows arrogance. And my article is already published in Astropolitics in the United States. I very much agree with you. It is incorrect. We have to do that. But there can be a solution. I mean, let's not behave negative. There is a solution. After, what are we wanting the common heritage for? Purpose is that all countries must get the benefit of any use of outer space. If a particular planetary body can give us a certain use, we can expect it. But the benefit must be spread over all countries. And as on today, we do not have the modalities of sharing that benefit. On what basis we'll share? Will it be on the basis of population? Will it be on the basis of area? Will it be in the basis of political clout? Will it be on the basis of GDP? What will be the basis on which this benefit will be shared? But what I have as a practical or pragmatic suggestion, that if at all, I mean, they may take another couple of years before they can do that. If at all they do that and they bring it, whatever profits they have, a part of the profit must be put in escrow account for the common benefit of all countries. So that if at all, when we have the modalities and the proportion in which this is to be distributed, that money is available and it can be shared by all countries. After all, let's not deny humanity something which we need. We have already overused our own mineral resources. We have depleted mineral resources today. And we need a lot of other precious and rare metals also, which are available in outer space on the planetary bodies. So let's not be negative, but this is outright wrong to do that on their own, unless they promise that the benefits which are assured for all countries shall be preserved, shall be held. Thank you.
Thank you very much. Well, I share your understanding on this problem. I have to say I'm not really hopeful, and right now, as people from academia, which as Article 11 suggests, we have to be informed on everything that Article 11 from Outer Space Treaty, everything that happens in outer space in the form of all kind of activities, we need to be made aware of it. However, I'm really concerned in relation to these huge investments that few American companies have made to prepare themselves, let's call it for the kill, to start colonization of outer space in mass level. So what we are seeing right now, it's huge. We're going to see huge tension, and I see also that the Chinese government is preparing. The Russians are responding very harsh to these acts, and instead of having cooperation in this new, relatively new field, and start from a new page of our civilization in outer space, how we do it, how we are positioning ourselves in the universe, we are going to replicate the worst possible things that we could take from here, which is very conservative form of capitalism, non-cooperation, and egoistical type of mentality. And to move it in outer space, I see it as really problematic. I really like your approach in, I think you call it World Space Authority. Well, I think this is something also very, very needed, in particular for space traffic management and for, as you have well put it, for space situational awareness systems, because it cannot be in the hands of one country. It cannot be hands in even the spacefaring nations. It has to be on something sui generis type of organization on an international level, and it has to be non-biased. So yeah, I will give the floor maybe to my colleague, Professor Gupta, if he would like to ask something.
Yeah. Am I audible? I hope I'm.
Yes.
Yes.
Thank you, Alex. And it is always wonderful to listen, Professor Sachdeva. And Professor Alex also has raised very important issue. So I have, Professor Sachdeva has named the presentation as the future challenges of space law. So very recently, what happened in India after the COVID lockdown, government has actually announced the called Self-Reliant India plan. So under this Self-Reliant India plan, Government of India also introduced some specific policies for, not policies, some announcement for space sector. So Department of Space very recently has announced two important organizations. And both these organizations are basically announced to deal with the private space activities. So one of the name of the organization is, in short, they call it In Space. So the full name is Indian National Space Promotion and Authorization Center. And the second one they are naming is New Space India Center. So both these institution that government of India is talking about is actually to promote privatization or private activities in space activities, mainly in India. Now, it would be great if Professor Sachdeva and Professor Alex, if throw some highlight, like we don't have any space legislation at place. And there are some important issues like security, how the liability will be shared in India in case you allow private activities in space in India. So as there is no space legislation, and the top of that, without any kind of explanation how this institution will be mainly working in India. So how you see the future of this new institution? Like already we have Antrix. Antrix mandate was also to like commercially explore outer space, maybe to some extent launching industry, government sponsored launching industry in India is quite successful. But again, another mandate of Antrix is to involve the private partners and launching industry, manufacturing industry, in these areas. So it will be great if Professor Sachdeva and Professor Alex if comment on these issues, like how in the absence of national space legislation or any clear national space policy, because at this we don't have legislation as well as very clear policy in India for private participation in space business. So and this, so how this new institution actually will be helpful, and what is actually government of India should do to make this institution more effective in private participation in the space industry. So this is from the this is the first question, and the second question that present.
Shall we take one by one?
Sure, sir.
Take one by one,
okay.
rather than.
Yeah.
May I take it on, Professor Alex?
Of course. I'm waiting for your contribution.
In India, today, the space agency is ISRO. And ISRO being a government agency, all liability is absorbed by the government of India through the Consolidated Fund of India. That is as per the Constitution. Now we are trying to encourage privatization. And we are trying to encourage private Indian corporate bodies to contribute to space activities in India. The problem which you have is, how exactly will the liability be covered? As you said it rightly yourself, one way to do that would be through a national space legislation. We haven't done it so far. We are very slow. Shall I put it extremely, because I was a panelist on that in 2017. And whatever we have done, even subsequently also, the comments we have sent to ISRO, nothing has happened. The bill remains a bill. But what really happens is, by default, it will be ISRO. By default, it will be ISRO, and all liability shall be paid out of the Consolidated Fund of India. But ISRO, if it's wise enough, can have back-to-back agreement with any corporate organization. A back-to-back agreement. They can have, okay, this is your share, this would be borne by us or the government of India. And the back-to-back agreement it's an acknowledged method worldwide for contractual liability. That is the only way under the circumstances. But state should not bear liability for private sort of a thing. And ISRO has already lost a case, as you would be aware, Deva's case. And it's not only that, there are a couple of more coming up. But I think we need to be a little more wise. Number one, to have the Space Legislation Act come up very fast. Number two, to be wise enough to have back-to-back agreements where liability is defined, responsibility is defined. And that is where, at this stage, responsibility will shift on to the operator. At this stage, a part of it will be borne by the ISRO or the state government. And such contracts are quite common. I think, no, please add on to that.
Wonderful. Yes, Biswanath, if I can add also, I agree completely with what Professor Sachdeva said. Obviously, if there is a issue with damages to foreign nationals, a state or private individuals, we know how it has to be resolved. Liability convention, we know Article 6 from Outer Space Treaty, jurisdiction of the state, it has to be on the Indian government, and the Indian government will choose how they are going to deal with this issue, because we know that it is it becomes political issue, and how damages are evaluated, things like this, which means you have asked, I think, a very open question, which is wonderful, Biswanath, because it starts. We have to start from the beginning. So what should the Indian government do? Obviously, they have started a process, and the legislation maybe will be the final chapter. But they need to identify all of the stakeholders, and they need to ask them what do they need. So how to incentivize private organizations to make business in outer space. So I think this is the first part, because if this stepping stone is not set, nothing else, everything else is just a blank document. After it becomes clear that investments could be made by the private actors, they have to be, in my view, if I'm a businessman who would like to use resources from outer space in the Indian, working with the Indian government, obviously they have to have very good relationship in sharing information, because many of the discoveries and many of the also of the potential information that they get, it could be used for national security purposes. So there should be some kind of very strong channel of a very good relationship between the private actors and the government. It could be in different forms. Obviously, the private actors have to be well vetted because they have to serve the Indian interest, and they also here the questions of registration, launching of facilities. This could be done. I think, as Professor Sachdeva said, this is not something innovative. Every nation has done it. The Russians have very good. The Europeans also have very good procurement contracts, etc. But I think the vital part is to sit on the table and ask them, what do you need? Now, if there are damages to to the government or to Indian citizens, obviously the government here can find a way to resolve it much easier than if the damages and liabilities on an international level. So can I return the ball to you, Biswanath? So what is your approach? What do you think is needed here? Because obviously you have thought on this issue as well.
Please permit me to add one more point.
Sure, sir.
Please.
Another solution which has been offered in the space legislation is insurance.
Absolutely.
Private companies, wherever they do that, they must insure against liability. It's a very expensive proposition. ISRO hasn't done it because ISRO was backed by the state power. ISRO is state government. But insurance is one aspect which will make their job a little more expensive, which will make their experimentation a little more high budgeted. But insurance can be one solution where it can be said that, okay, you insure your against liability.
Yes, yeah. There are many things. For example, because it's a relatively new industry, maybe also the approach of using reusable launching, reusable rockets, basically, it will become a very good investment, and it will also preserve the outer space environment from the creation of additional space debris, which can be avoided. This is just an example of win-win scenarios like this. So yes, Biswanath.
So very recently, what we did, we actually researching
You had
on
a
these
second
issues.
point.
Yes,
This
sir.
why you had a second point.
So just let me share my what we did basically in the first point. So we tried to develop a model, like a kind of liability sharing model. And very recently, we also shared our opinion with BWARE, mainly about the National Space, the In-Space Organization. So we are basically in the process of or researching how we can develop a model apart from insurance. What are the other mechanism of liability sharing we can add to make it a very sustainable model for Indian space industry? So my second question is about from the perspective of international law and international humanitarian. So very recently, we are also working in the second project. So we almost like compiling the work. The work is basically the autonomous weapon system and international space law. As you all aware that US and Russia and China, even India, is actually somewhere declaring that we space force, that US has, President Trump has already declared that they are planning to develop the space force. So how you see the scope of autonomous weapon system, international humanitarian law in one hand and space law in the other hand? So how we can see the development, international law should respond when we are entering into a new area of space force and the autonomous weapon system in one hand. Yes, over to you, Professor Alex and Sachdeva. Okay.
Well, Space Force is something new. In fact, astronauts already constituted the Space Force. But with the proper formalization of a Space Force, it brings out the motivation or the intention that they want a force. It's whether you call it as a veiled threat, or you call it as a force, or you call it as a manpower available for space activities or whatever be. But force has got defense or military nuances. It has got military nuances. It has to be something which is military, which is aggressive. And this, as per today's law, does not permit, because militarization of planetary bodies is not permitted. It's just against the law. But the problem is, today you don't have to go to a planetary body to fight in outer space. You can do right from the Earth itself. You have cyber, you have lasers, you have lots of methods today where you don't have to go to outer space to fight in outer space. You can do it from here itself. And they've created a force. And it depends on human ingenuity as to how far and to what extent we can create an effective space force and where we can use it. Is it defensive? It is tactical? It is strategic? There are a lot of questions to be answered. And I think though President Trump has inaugurated United States Space Force, I think even they themselves are in a dilemma as to what to do really. They haven't got the hang of it. But gradually with time, things may happen, and it could be a race. I don't wish it happens, but it could be a race towards doom. It's not a desirable step. If at all he had said he's created a space force for peaceful uses, oh great, it would have been a wonderful idea. But to create a space force as part of the defense services, it has different meaning and motivation altogether.
Mm-hmm. Yes, again, I agree with these comments of Professor Sachdeva. I would say even if the Americans are masking their activities with peaceful use, the representatives of states and the states, the governmental officials, they are aware of what is happening sometimes, because we have seen this happening also. But we have less tension in the international arena as well. Well, Biswanath, in relation to the Space Force, I have to say, for me, it was this kind of structures. They have existed in other states, by the way. That it's not maybe not in so separately and so separately stationed in this architecture of defense, but in the Air Force of the United States, they have been there, and also maybe in some other structures which are not made public, because we have to remember that today I'm always reminding my students that we are not dealing with the classified world, with the classified information. So as Professor Sachdeva said, it is forbidden to have weapons, particularly for mass destruction in outer space, but we cannot check what kind of weapons are there weapons in outer space. We cannot check this. So and by seeing what is happening, and by seeing by knowing how vital outer space is for military purposes, because it is the ultimate high ground today, it is clear that states will want to, particularly the United States, they will want to be dominating this arena and being at least the leader there. However, we have seen that also that there is a problem, not only because of the anti-satellite capabilities that China, India have developed. The Russians have already developed it in the Soviet times, very good capabilities. So we are seeing here, in my view, Biswanath, we are seeing in international law a conflict of perception. I call it a silent dialogue and with statements, which is the United States want to preserve their identity and their pretense of being the state which is above all others, which for which international law does not apply, not a partner to everyone else, a state which can shut the door or stop sharing information on satellites, or just close the GPS for you, or just stop your bank accounts by turning the SWIFT off. So this type of instruments, which have a global, very important character, they were in US hands in the last, maybe not since, but until 2005, let's say. After that, we have seen states becoming much more independent, cooperating. We have seen BRICS. We have seen the EU states also trying to have their more or less independent position in foreign affairs, and the Russians have regrouped. Let's put it in this way. So if you're asking what we're going to see, what I am expecting is we are going to see a show of force of everybody else to show the Americans that they will not be able to keep up with their intention of being the exceptional state in the world. It's not going to be possible anymore. So the Russians will show again what they're capable of. The Chinese will show what they're capable of. They will stand together, probably. BRICS countries, India, will have to choose carefully its place, but I think it will be on the side with the Chinese and the Russians on this particular part. And it will be very interesting to see what will happen in Europe, because Europe was, the European countries were more or less given as an extended hand of the United States in the world. But today we have seen a change of leadership in the United States. We know what happened. So the relationship between the Europeans and the Americans is not what it used to be 5 years ago, 10 years ago. And I hope that we are going to see much more independent European player which knows its interest, and they are not. It's not in their interest, their neighboring country, Russia, to being able to attack every city if this has a potential with weapons that they cannot stop. So, and they have some decent relationship with Russians in energy sector and other sectors. So I think we are going to see this play out in the near future, Biswanath, and I think it's going to be this kind of silent dialogue that I have mentioned. Again, I'm returning the ball to you. What are your thoughts on this, Biswanath?
Thank you, Alex. I still look at it that Space Force is more as a political gimmick. Number two, it's more as a, it goes with the personality of President Trump as a flamboyant sort of a thing. It's not going to be a real force, number one. Number two, Russia is more mature in its international relations. And they have not shown any sort of a comment which is aggravating or something like this. And so far as the European Union is concerned, European Space Agency and all that, they are more of a pacific sort of a thing. And they have no ambitions of annexation or doing anything or something like this. So I have a feeling that this Space Force would, if it doesn't die down, it will become a very mellowed idea. It's not going to be a very aggressive idea as such. That's my view of this. And Russian response to this has been very mature. They have not come out with any big statements, oh, here you are, we can do this and all that. A very mature response. And America can be condoned because President Trump's personality, President Trump's ideas, President Trump's actions, and maybe what happens in November, we don't know.
Yeah.
So thank you very much.
So I agree with Professor Sachdeva and Alex. So very recently, Russia has actually argued for, if I'm not wrong, Russia has argued for a comprehensive certain protocol or some certain international treaty actually to control the Space Force. So what we are basically doing, we are actually looking into very specific aspect of Space Force. So autonomous weapon system. So as Professor Sachdeva has correctly pointed out, that installation of military weapons in the planetary bodies are not allowed. So our research is basically to find out whether autonomous weapon system can be installed in any of the orbit or any of the other places or not. So we are like in the process of actually researching this. So this is from myself. Okay, thank you. This is from myself.
All right, thank you very much. I agree with you. I think if students have any questions, we can answer that.
Thank you so much, Professor Milanov. Yes, sir. Thank you so much, Professor Milanov and Professor Gupta. Professor Sachdeva, we'll hold on to you for another few minutes because, yes, there are a few questions. They've mostly been addressed by you, Professor Milanov and Professor Gupta, but just a couple of related ones perhaps that haven't really been discussed. So the first one I have is, the students want you to share your thoughts on the security of space assets, for instance, having a mining code similar to the ISA. And a related question, how can you make sure that if you're using resources from the moon and perhaps Mars sometime in the future, how do we make sure that they're put to sustainable use considering the penchant of humans for, of course, making it quite unsustainable for the rest of the species as well?
Okay, let me repeat if I've understood the question right. The point made is that when we use natural resources from the planetary bodies, how do we get over the problems and how much can we use?
Right, yes.
Right. Number one, we can never exhaust the universe. not only the planets which are close by, but I think with years we'll get opportunity, technology, and perhaps we'll be able to go far beyond. Natural resources in outer space are tremendous indeed. We'll never exhaust them. Now, the point is, the law doesn't permit this. Law doesn't permit private sort of appropriation. Now, how do we get over this? Without the legal sort of a thing, one pragmatic or practical solution could be that, yes, we go ahead with this. We do that. And after all, we are doing it. If it's a commercial venture, it is for profit. And if it is for profit, if a certain part of profit is deposited in some common fund or an escrow account, then that can be distributed for benefit of all countries. Ultimately, why we don't do that is because modalities for distribution are not there. If we can distribute to different countries who are to benefit, then there should be no difficulty. Like, I'll give you an example. We had the same problem in the law of the sea. We had that granules and sort of a thing. Now, technology was available, but the law didn't permit. We didn't agree. The world said, no, 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 no. And what the Americans did, they took those granules out, used it. They said, we are taking our own share. Now do what you want to. After it's a common heritage of mankind. What have we done with that? Best would be to be cooperative. Let's try and find a way out and still get what you want. You get your pound of flesh also without letting any blood. That should be our approach. And that is where I made this point. Yes, no problem. If America can go ahead and do that. But please deposit certain profits so that they can be shared. If anybody else can come and do it, let him also do that on the same condition. On the same condition. Let there be transparency, let there be parity. In fact, America itself is trying to propagate this sort of a concepts under the Artemis Accords. They are bringing about this. That's what it is. So let's not stop it. Let technology develop. Let's be practical enough to do that. And the best would be that whosoever does it, honestly share it. I would only say
that. Ankita, can I take on this question as well?
Yes, Professor Milanov,
Sure,
absolutely.
Okay, thank you. So very quickly, in my view, what Professor Sachdeva said, it is the most likely scenario, especially when states are involved. At some point, they will find a mutual agreement how to share their resources. In relation to the seabed authority, as we know, students can check how the resources from the seabed are distributed today. Even though that it is common heritage of mankind, I don't like at all the principles that are applied there, because when we talk about mankind, and I speak a lot about this, when we talk about mankind, we are not speaking about states. We're not talking about all of the states, spacefaring nations as well. So here, because it is something that could be envisioned, and the principles can be charted, has yet to be drafted, let's say, how outer space resources can be exploited for the benefit of humankind. In my view, we need to have a new type of identity, new type of organization, which is the organization of humankind. And this type of organization will have nothing to do with governmental representatives. Because even today, if let's say India receives 5 tons of helium-3 from the moon, will it go to all 1.3 billion people of India? No. or will it be beneficial for them? No, the same is valid for every country. So governments, they, especially rogue states which are not, they do not India, I mean here, but states which do not care for their people at all. We have dictatorial regimes in which their representatives, they will not give any kind of access or any kind of benefit for the human beings that they are in charge to take care of and to be of service to. So in my view, we need a new approach, and this is in relation to allow the humankind or support the humanity to emerge as a separate sui generis legal subject with its own organization and capacity to utilize the resources of outer space. So these are my thoughts on this. Thank you.
I'll add a word on that. There is a school of thought going on which is propagating that benefit of humanity or the benefit of all countries turns out to be an unearned profit. The countries which are not participating in space, the countries who are not bothered about space, the countries who have got no interest in outer space, I mean, where is their contribution? And why should they share a part of the profit? So there is a school of thought which says this turns out to be unearned profit. And unearned profit is not a right. Unearned profit is not a right. So how much should be given, should not be given, as Alex said, that countries don't care for their people and all that. So these are modalities. On what criteria we make these modalities, it's purely international community or corpus or some sort of an organization. But better still, it would be, just as I've suggested, there is need for a world space authority. Let that be a composite authority. Let them decide what to do. Give them the powers to do that. And once we create an authority, world space authority, they'll become responsible for all that. And they'll be responsible for traction also, how to move these ideas forward and how quickly to get them over. So institution would be World Space Authority, but that's my suggestion. It can be modified anyway. Thank you.
Professor Gupta, I think perhaps wanted to add something to this.
Yeah, just one line.
Please
I'd like to echo with Professor Alex that yes, the word that is used in International Space Convention, it is mankind. So, like as Professor Alex has rightly pointed out, in many of the times, the states generally don't share their benefit with the citizens. So there we have to ensure that the mandate of International Space Law is benefit of the entire mankind. So that points obviously we should ensure when we are going to use the space resources when we are going to use the space resources. Yes, thank
you. Thank you so much, Professor Gupta. And I think Professor Sachdeva and Professor Gupta and Professor Milanov have quite comprehensively answered all of the questions that came up during this webinar. And so, Professor Sachdeva, any closing remarks from you?
Remarks?
Closing remarks.
Okay. Let me put it this way, that outer space activities are expanding because of technology and because private enterprise is becoming more enterprising. They have the money, they can buy technology, they can buy skilled resources, and they can get into outer space. And since state-funded agencies are going out, private sector has got a space to fill in. So as such, we have problem of private sector coming in. We have technology which is making viability of a lot of commercial activities, whether it's a service like space travel and tourism, whether it's excavation, like we have commercialization of natural resources, or we have the space habitations. These are coming up in a way and are becoming viable and feasible in the very near future. And with these, the problems which are coming up like space travel, we need to have a contract. Dennis T2 could have a lawyer to look after that, but a common man will be more excited about the experience rather than the contract. He will sign at any, the way we do it. The way we do it for our air contracts, we accept, okay, Warsaw conditions are accepted and liability will be at that. So it's time that we try and create certain conditions which are in favor of both the carrier, which will be your space carrier, and the person who is to go, the passenger. So we need to bring in equity and equality so that exploitation is not there. Similarly, there should be no exploitation of resources. It is said, we have said that, okay, they should be commonly shared. But why should they be commonly shared? If a country has not shown any interest, it's not a spacefaring country, they have not spent any money, what share they should get? Unearned money. But at the same time, space treaty is a very altruistic. It looks after the interests of everyone. It's very altruistic. So keeping that in mind, we should do that. And when crimes come up in living together, we have to have a way. And what exactly we need to do today is first create a world space authority which can look into these problems, because Corpus is not. United Nations says, do this, they do that, do that, they do that. It's not an independent self-thinking organization. We have to have something with initiative, with the thought process, with mindset. And that is where something like a world space authority could fit the bill. It could be called by any name. I've just said it. It can be debated also. But it has to be something like this must be brought, which is a self-thinking, and they can bring about a change and they can look ahead at the challenges. We should not reach the challenge and then do it. We should look ahead on that. Like debris, we never thought in 57 that this could be a problem. But debris today, space debris is a major problem. So it should be a self-thinking organization, which is futuristic in approach and proactive also. It need not be reactive. It has to be proactive also. Thank you very much. That's all I have to say.
Thank you so much, sir, on behalf of the entire JGU family for joining us and sparing time on a weekend and teaching us all so much. And also thank you to my colleagues and all the attendees. Hope you all have a great weekend and stay safe. Thank you so much.
Thank you very much. Thanks. Bye and Dasvidania.
Thank you, Ankita.
Thank you, Ankita.